In this video, we're going to talk about what a durable asset power of attorney is, how it works with your estate plan, and why it's such an important document. When you sit down and build your estate plan, you often focus on what happens after you die. That is wise. But protecting your ability to act today and looking out for the time you cannot act are equally essential. One of the most important tools for that is what we call a durable asset power of attorney. We will walk through how it works, what it consists of, why it matters, and how it fits with a living trust in a California estate plan. So, what is a durable asset power of attorney for asset management? You are the principal when you sign a power of attorney. You designate someone you trust, your agent or attorney in fact, to act on your behalf in financial, legal, or property matters. A durable power of attorney means that your agent's power continues even if you become mentally or physically unable to handle your own affairs. California law defines it as a power of attorney that contains words like, "This power of attorney shall not be affected by subsequent incapacity of the principal." When we say asset power of attorney, we mean that the document gives authority over property you own or will own: real estate, bank accounts, investments, business interests. It is not the same document as your healthcare directive, though you may create both. What does such a document consist of? Well, in the document you will, number 1, name the agent you trust. Number 2, you'll specify the scope of powers, such as paying bills, managing property, handling business interests, signing documents, filing tax returns, and acquiring or selling assets. Number 3, you'll include the durable language so that incapacity does not terminate the authority. Number 4, you'll make sure to state when the power takes effect, immediately upon signing or upon a specified event, such as incapacity. Number 5, you will make sure the document will be dated, signed by you, and either notarized or signed in presence of 2 adult witnesses per California law if it may affect real property. Number 6, you may also include an optional set rules or limitations on your agent's authority. For example, a clause that states that you will always remain able to act while you are capable. Here's an example of why this document is so important. Jane and Mark are married homeowners in California. Jane is the primary breadwinner. One day, Jane is injured in a car accident and is hospitalized, unconscious for days. She never signed a durable power of attorney naming Mark as her agent. Her bank refuses to let Mark access her accounts or pay bills because Jane is incapacitated. Mark must file for conservatorship to get the court's approval to act for Jane. Meanwhile, bills go unpaid, mortgage payments fall behind, the house payment misses, and credit damage follows. The family endures legal fees, delays, and loss of privacy. If instead, Jane had signed a durable asset power of attorney naming Mark, he could immediately step in, use the bank accounts, pay the mortgage, protect the house, manage business matters, and keep everything stable. The injury did not just cause physical harm, but triggered a chain of financial and emotional risk that one document would have prevented. How does a durable power of attorney for asset management work with a living trust? Well, in California estate planning, your core estate plan often includes a revocable living trust. You transfer your assets into the trust while you are alive, you serve as trustee, and you designate your successor trustee to take over if you become incapacitated or die. The durable asset power of attorney complements that trust. While the trust handles the management and distribution of your trust assets when you cannot act or when you die, the power of attorney gives authority over non-trust assets, or assets you forget to retitle into the trust, as well as legal authority for your agent to deal with third parties, banks, real estate transactions, etc. If you become incapacitated before you die, your successor trustee under your living trust steps in to manage trust assets. Your agent under the durable power of attorney handles your non-trust assets and executes tasks you set out in the power of attorney. The combination ensures neither gap nor court involvement. Without the power of attorney, the trust alone cannot reach non-trust assets or step in at the moment of incapacity for you personally. Your ability to act for yourself today matters. Your family's ability to act for you tomorrow matters. If you have not signed a durable asset power of attorney, you are leaving a door open to risk, delay, cost, and uncertainty. Start the conversation with your estate planning attorney. Include the power of attorney with your living trust plan. Name someone you trust and make sure everything is signed, dated, and valid under California law. Share with family, ask questions, and reduce the burden before something happens. If you have questions or would like us to help you with this, give us a call or shoot us a message via the link in the description. We've been helping California families for decades with their estate planning and other legal needs, and the chances are good that we can help you too.